legal scholars had some reservations. And it occurred to me that there was a real society that I knew about which had done more or less what the economists were proposing. That is, set up a system in which the prosecution of a law case was like a tort case, meaning that the victim is in control of it, rather than like a criminal case, meaning that the police are in charge of it. And so I wrote 2 articles that were part of that controversy. And I learned a good deal about the legal system of Saga period Iceland, which is the one that I had heard about. I don't know how much you people know about it, but I should say that I have argued that it is competitor with Periclean Athens, considered as a source of literary production per capita. It's quite a lot later than Periclean Athens. The Saga period Iceland is about 1000 AD. And I learned a good deal of interesting stuff in the course of doing that. But then I didn't do anything else with other legal systems. And eventually I got interested in the legal system of England in the 18th century, because that was a system where prosecution of law was private. In the Icelandic system, not only the prosecution but the enforcement was private. That basically in the Icelandic system, if somebody had wronged you, you went to the court system, you got a verdict against him if you win your case, and he then either paid or did not pay the damages he owed. If he didn't pay them, he was outlawed, and it was now legal to kill him. So it was an interesting system, and it produced. Saga period Iceland had a population of perhaps 50 or 70,000 people. There are, I would guess, 10 or 15 books that were written by them that are currently in print in English translation. That's why I said it is comparable to Periclean Athens as a society a long time ago that produced stuff we're still interested in. But in any case, I got interested in the English case, and I wrote an article on that, and I learned lots of interesting stuff. And then I was lazy for a long time. And then it occurred to me that this had really been a productive kind of activity, kind of research. So I announced that the next year, I was teaching in a law school at that point, that the next year I was going to have a seminar on legal systems very different from ours. And I went into our library and I asked them if they could find me some books. And they presented me with a rolling bookcase, a couple of levels high, full of books on odd legal systems. And I taught the seminar, and I taught it every other year for quite a long time, and accumulated a lot of stuff as a result, and eventually made a book out of it. So that's sort of the origin of this particular project. The basic idea is that all human societies face about the same problems. They solve them in an interesting variety of different ways. And they're all grown-ups. That one should not think of Aristotle or Snorri Sturluson for the Icelandic stuff as primitive people. Some of them were very smart. And they have ideas we might want to use and ways of looking at the law which might help us to understand it. The systems that I cover range from imperial China and Periclean Athens, those are the first 2, to modern Amish and Romany. I am not asking the question, what is the best legal system? Because I don't think there is one. I think that depends on the circumstances of the society. But rather, I want to understand each of these systems and also look for ideas we might want to steal. That's the basic version of it. I thought that since I was giving this talk in Athens, I would start with Periclean Athens, which turns out to be one of the very interesting legal systems. I like to refer to it as the legal system of a mad economist, because the Periclean legal system is full of clever solutions, which might or might not work, to various of the problems that they and we face. let me start with what I think of as the deep pockets problem. That if you have something like tort law, it is tempting for you to look for somebody rich and preferably unpopular who you can claim wronged you, sue him, and hope that the jury will agree with you. That problem also exists with criminal law, that if you want to get somebody, there's a saying in American legal culture that you can get a grand jury to indict a ham sandwich, that you can always find some excuse if you're good enough at it. And one way of doing that is to use that against people, either to get them to pay fines to the state. Donald Trump, as you may know, was judged in New York as owing an enormous amount of money, basically because when he was borrowing money from banks, he exaggerated how much the property that he was using as security was worth, which I suspect the banks expected, that usually people exaggerate how much things that they want to borrow on are worth. But the Athenians did it two ways. Their equivalent of criminal law was privately prosecuted by essentially any Athenian citizen, I think. And the incentive to prosecute was that the prosecutor got a share of the fine that was collected from the from the defendant if he lost the case. Their solution to the problem was that they had big juries, many, many more people than our juries, than American juries are. And if you failed to get a fifth of the jurors to vote for conviction, the prosecutor was fined, quite a sizable fine. The tort equivalent was that if the plaintiff lost the case, if he failed to convince the jury that he was owed damages, he owed the defendant a sixth of the amount that he had claimed the defendant owed him. And those both sound like interesting approaches to a problem we still have. Next problem, they had the problem that all societies do of how do you pay for public goods. I should say a public good in the economic sense doesn't mean a good that government produces. It means a good that the seller can't control who gets it and therefore can't fund it by just selling it. So a radio broadcast, for example, is a public good, although it happens in the US that almost all radio broadcasts are privately produced. But the Athenians had an interesting way of paying for public goods, and that was that if you were one of the richest Athenians, you had to produce a public good every 2 years. So you're a wealthy Athenian citizen, and the relevant official of the government comes to you and says, you know, we're sending a team to the Olympics this year. Congratulations, you're the sponsor. Or look at that lovely trireme down at the Piraeus dock. This year, guess who's paying its expenses? Actually, I think a trireme took two rich people to support it. And there are two ways of getting out of that job. One of them is to demonstrate that you are already producing a public good this year, or that you produced one last year. The other way is to show that there is another Athenian who is richer than you are, is not producing one this year and didn't produce one last year, and now he has to do your public good. And the puzzle is how in a society 2,500 years ago, roughly, which doesn't have accountants, doesn't have computers, doesn't even have banks in our sense, how do I prove that you are richer than I am? And it's an economist's answer, not an accountant's answer. Anybody who hasn't read the answer want to propose a way?
Explains the properties.
I offer to trade everything I own for everything you own, And if you turn me down, you have just confessed that you're richer than I am. And it turns out that that mechanism is actually used in at least one modern context. There are horse races where they're trying to get all of the horses to be roughly competitive at the same level. They're called claiming races. So if you have a $1,000 claiming race, that means that if you enter your horse in a $1,000 claiming race, you are offering to sell it for $1,000. And obviously a better horse you wouldn't enter in that, but you might enter it in a $5,000 claiming race. So I thought that was interesting. I didn't know that when I originally read about the Athenian case, but I thought it is now. Another problem. Under Athenian law, if I search your house for something that I claim you have stolen and find it, I not only get the property back, you owe me the value of the property again. And this raises the obvious possibility of my planting the evidence. Just as we worry in the modern society that police who want to get a good conviction rate might bring drugs with them when they search the house to find drugs. The Athenian solution, which probably would not be acceptable in modern day America, is that you can search his house, but you have to do it naked. So you can see why I think of Periclean Athens as the legal system of a mad economist. There are lots of other features of it, I should say, some of which I don't admire. For example, if a woman was an heiress, meaning that her father had no sons, she could be required to marry the closest kinsman who would have her. So it's not a wholly desirable system. Oops. For some reason, I've just lost the ability. Here, let me.
Okay, good.
That worked that way. I'm not sure why it didn't before, but we'll see. All right, imperial Chinese law. This one is almost as old as Athenian, and unlike Athenian, it lasted for about 2,000 years, with occasional intermissions in between dynasties. Imperial Chinese law has a bunch of interesting characteristics. One of them is that it is, on paper, what I thought it was when I first investigated it, was the mirror image of Iceland. That Icelandic law, in effect, is all tort law. There is no criminal law. In theory, imperial Chinese law was all criminal law. There was no way to sue somebody. So if you imagine that you're a peasant who's lent some money to another peasant, and he doesn't pay you back, you can't sue him for the money. All you can do is to go to the district magistrate and accuse him of being a swindler. And the district magistrate can accept the charge. He can refuse to accept the charge. He can decide what punishment he looks for, and so forth. That's the version of the legal system that the elite believed in. After Mao's death, when China opened up, people got access to the records of local courts. And it turned out that that's what happened in theory. But what happened in practice was that I go to the district magistrate and I say, I'm charging so-and-so with being a swindler because he hasn't paid me back the money I lent him. And the district magistrate, who is the busy man, says, all right, come back in a couple of weeks and I'll deal with the case. And I then go to the guy who hasn't paid me the money and I say, look, if he convicts you of being a swindler, very unpleasant things are going to happen to you. You will at least get beaten. You may get exiled some substantial distance from your home area. Why don't you pay me the money? And you pay me the money, or maybe we compromise and you pay me some of the money. Now, I can't drop my charges, right? It's in the hands of the district magistrate. But the district magistrate is a busy man. So when the two of us go to him and humbly request that he drop the case, he drops the case. So I think of that as, sorry, something went wrong. I think of that as the substance of tort in the form of criminal law. But there are lots of other interesting features. In the late periods of the Chinese Empire, they had a population of about 400 million people, which was enormous in terms of pre-modern societies. And they ruled it with a relatively small bureaucracy of elite scholar officials. Those were the magistrates. How do you do it? And they did it in two different ways, at least two different ways. One of them was that they subcontracted the job of enforcing the law mostly to the extended family. They set up rules designed to give the older, more strictly the higher on the tree, as it were, members of the family authority over the lower members of the family. So among other things, reporting your parents for a crime they had committed was a crime by you. That's unfilial behavior, right? The punishment if a uncle beat up a nephew, the punishment for that was lower than ordinary people. And if a nephew beat up an uncle, the punishment was higher than ordinary people. Let me go back. Something which I thought I had here but didn't. That's all right. The second way they do it was to make interacting with the legal system as unpleasant as it could be. Witnesses, for example, could be tortured in order to make sure they told the truth. If you look at a description of an imperial Chinese trial, everybody other than the judge and the court officials is sort of on his knees, behaving as a very humble person, and in general, yes, this is the one. One implication of that is that if you wanted to get somebody in trouble, you could post an anonymous accusation against him, and that way, since it was anonymous, you wouldn't get involved. And getting involved with the legal system in any way was very dangerous. Sensible people avoided it. So it was a crime for an official to read an anonymous accusation, a crime by the official, in order to block that. At least all of this is my interpretation of I'm describing the rules and then giving my view of what they were doing. Another feature of that system was the original civil service exam. The imperial exam consisted of 3 stages. The first and easiest stage was one which in the late period of the empire, about 500,000 people had passed. And that gave you some status and some minor legal advantages. But the main thing it gave you was the right to take the second stage. The second stage exam had a pass rate of about 1%. If you passed that, you were quite likely to get a government job, and you had the right to take the third stage, the metropolitan exam, and that had a pass rate of about 3%. So you can see in what sense it was a very elite body of scholar officials. Now, what did they test on? You would think you would want to test on the job of being an official. But in fact, the subjects were literature, philosophy, calligraphy, verse composition, the abilities of an educated gentleman. And that's a puzzle, because this studying for the exam basically consumed the life of somebody, that you'd be studying from the time you were fairly young. If you were a very bright kid in a village, the village might agree to support you on the grounds that if you did get an office, you could benefit them. So the question is, why did they do it with such an irrelevant set of subjects? And one possible explanation was it was an IQ test, that they wanted very smart people as their officials, and the ability to memorize all of the important works of Confucian literature and to impromptu compose verse and things like that, so that were tests. I find that implausible because there ought to be cheaper ways of testing IQ than having somebody spend a sizable chunk of his life learning more or less useful things. The alternative, which I find interesting, starts with the observation that there are two things you want of your officials. One of them is that they are able to do a good job, and one of them is that they want to do a good job. You want to have officials, if you're the emperor or the people representing him, who think of themselves as the mother-father figure for the people underneath them, who are conscientiously trying to make the people under them better off and are willing to obey the people over them. So an alternative is that it was essentially a form of indoctrination. It occurred to me reading of this that this was not really as odd as it sounded, because after all, if you want to have an important job in America, you have to graduate from college. And what do you learn in college? Well, if you're going to be an engineer, one of the things you get graded on is your knowledge of English literature, which is not a really high-level skill for an engineer. And if you want to be a social worker, you've probably got to get at least some minimal grades in mathematics and chemistry, and not necessarily specifically that, but in some, you're likely to be at a university which requires that you take a science course even if you're not doing science. So I like to say that the imperial exam system is alive and well in the United States, for all I know in Greece as well. Another system that I found interesting, and this is one that's still around, are the Amish. I don't know how much you people know about the Amish, but they're a religious group who emigrated to America from Central Europe. There are no Amish left in Europe as far as I know. They're mostly in the US and Canada, maybe a few groups elsewhere. And people think of them as sort of idealized 19th century farmers. And that's a useful image which helps them win their cases against the government when the government tries to make them do things. But in fact, I think that's wrong. I think that they are maybe the more advanced people than the rest of us. They have all sorts of rules, but they're basically anarchists in the sense that the rules of a congregation is 25 to 40 households, and the reason congregations don't get bigger than that is that the Amish do not build churches or meeting houses. So there have to be a small enough number of people in the congregation so they can all get into one large barn or one very large farmhouse for their services. Each congregation has its own ordnung. Obviously, they to some extent imitate each other, but they not perfectly. And the ordnung is only binding on those who have sworn as adults to accept it. So if you are a 14-year-old Amish kid, you may well try to do the things your parents do, but you are not obliged, as far as the Amish system is concerned, to obey any of their rules. And in fact, some Amish communities have the sort of pattern of the teenagers going off and doing things that the adults aren't allowed to do, such as driving cars, for example. And then when you're an adult, you decide whether you want to be part of this or not, and most of them decide to stay with it. The ordnung of the congregation is modified by unanimous assent, And a lot of what the ordinance specifies is technologies you're not allowed to use. For example, Amish, at least the more extreme Amish, don't drive cars, use horse and buggy. They're sort of noticeable and a bit of a traffic hazard in places where they exist. And it's enforced by social pressure and ultimately by my doing, which is ostracism. So if your community says you're not allowed to drive a car and you insist on driving a car, the first time or two you will be warned, but if you keep doing it, you eventually get ostracized, which means you can interact with other members of your congregation only in very limited ways. The sense in which I want to think of, say that they are more modern than the rest of us, is that what the restrictions are largely about is preventing technologies that they think would undercut their social system. In particular, Amish don't have telephones in their houses because the telephone, like the car, gives you a social network which is widespread. It means you can be interacting with people all over the place. And they want a social network where most of your interaction is with fellow members of your congregation. It works. There are about 250,000 of Amish, and there are going to be more, because the Amish combine modern medicine with traditional birth rates. The result is that their population doubles about every 20 years. So assuming that non-Amish, English is what they call it. I should say the Amish have their own language. They have a German dialect. In fact, they have two German dialects. Well, three in a sense. One group of Amish have one German dialect, one group have another, and their religious work is in an earlier dialect of German. So they refer to us as English because we're speaking English. They all speak English too. Basically, any Amish will normally be trilingual in the religious dialect of German, the Pennsylvania Dutch, which is the term for the dialect of German that the Amish have, and English. They're interesting in a bunch of other ways, and if you read my book, you can discover much more of them. But I thought it was sort of neat that you have a society which appears to be very regulated, but entirely by voluntary arrangements. Next, go to another one that's still around, the Romani, commonly called gypsies. I think Romani don't really like the term gypsies, and the term has the disadvantage that it also describes a lifestyle which some non-Romani groups also have. The Romani, we now believe, left India about 1,000 years ago, and they migrated to various places. One of the interesting things is that the different Romani groups have somewhat different legal systems, so you've got a sort of comparative law opportunity. The Finnish Romani are, I think, the only human society I know of which does not concede the facts of human reproduction. They don't have marriage, and traditionally, if a couple in effect want to get married, they leave the community for long enough until they have produced a child who is old enough so that it is not dependent on being with its mother all the time. They then come back and are very, very humble because they've obviously sinned in some way, and the baby is taken care of by his mother and the other women of their generation. Anyway, those are the Kale gypsies. There's lots of interesting things about them. But the particular thing that I wanted to comment on is that it is what I think of as an embedded legal system meaning that the Romani are in places where there is a government whose laws apply to them, and they largely avoid that by staying below the radar. For example, in a traditional Romani family, first names are, as it were, family property. So that I'm John this time, but if you want to interact with the official things, you might be John next time. And they avoid registering births, avoid doing things of that sort. And one of the things that makes it easier to do is to avoid state law, which they do pretty well. However, there's other advantages. The Nazis tried to kill off both the Romani and the Jews, and they got a much larger fraction of the Jews. Enforcement, there are a couple of mechanisms. They have their own rules. I like to describe part of it as Orthodox Judaism on steroids. There are elaborate rules of pollution. For example, a Romani will try to avoid living in a place where there are other people above him, because the bottom half of the body is unclean. So the clothes, I think they have 4 or 5 different washing batches of stuff for laundry. Lower half of the body, upper half of the body, male, female, and I think there's another division that I'm forgetting. So it's a weird system, and some of the enforcement is by what's called the Cris Romani, which is essentially all males or all adults, depending on the particular Romani group, meet together and they talk about a dispute. The dispute is about whether somebody has violated the rules and therefore is polluted. It could be about something else, but and until they reach an agreement. And then the punishment is marame. Marame is being polluted, and that prevents other people from associating with you, not because it's against the rules, because they'd catch the pollution. Anyway, it's a weird system. Part of the reason it works is that everybody else hates them, and they hate everybody. I exaggerate only a little. That in general, they've, in most societies, had the reputation of being people who steal chickens and maybe babies, and their view is that the rest of the world is unclean. I mean, we're all polluted. We don't follow the proper rules. And that means that being, in effect, ejected from Romani society is a sort of social death sentence. There's nobody else who will associate with you. And one result is that in the US, which is a very tolerant society, the Romani are disappearing. That is not the people, but the culture is disappearing, because it's relatively easy, if you try to enforce their rules, for the person you're enforcing them against to, in effect, blend into the surrounding society, which was not workable before. All right. Let me go on to 18th century English criminal law, which, as I say, was one of the things that I thought was fun. They have essentially the same, on paper, more or less the current Anglo-American system. There where we got it from. They have the division between criminal and civil, between torts and crimes. However, there are no police or public prosecutors. Any Englishman can prosecute any case. So if you are the victim of theft, it is up to you to bring the evidence to the court, prosecute the case, and then the convicted person gets punished. Unlike the Icelandic system, the punishment is by the state. So the state enforces the verdict, the state runs the trials, but what the district attorney or the prosecutor would do in our system is being done by the victim, or somebody on behalf of our victim. Just as in the tort law, that's the case, and it's usually the victim's lawyer, not the victim. One of the puzzles this raises is, why does anybody bother to prosecute? Because a tort case, if you win the case, he owes you damages. A criminal case, if you win the case, he gets hanged or transported or pardoned and let go. Those are all options. And I think there are at least two reasons. One of them is that you can't collect damages if you convict him, but you can settle out of court. That is to say, if it's clear that something terrible is going to happen to him if you push the case through, he might be willing to bribe you to drop the case, or just to prosecute it very badly. Doing that was illegal, but there's quite a lot of evidence that it happened. Second reason is deterrence as a private good. And if you imagine somebody who is a likely victim of theft, say you're dyeing cloth, and you've got all this valuable cloth spread out drying all the time, so it'd be pretty easy for somebody to steal from you. You would like the reputation that if someone steals from you, he gets hanged. That works for some people. It's not going to work for most people. And the solution they had for other people was prosecution associations. You have a bunch of people in a town in England who join an association for the prosecution of felons. They pay an annual dues to it. And if one of them is the victim of felony, the money that the association has can be used to prosecute the case. And the final critical step is that the membership list of the Association for the Prosecution of Felons is published in the newspaper for the felons to read. So it's a case of pre-committing to deterrence, which I thought was very neat. What first got me interested in 18th century English criminal law was that all serious crimes were capital. Stealing more than 40 shillings, for example, was a capital offense. Stealing in a way that put the victims in fear was a capital offense. Stealing a sheep was a capital offense. In fact, there's a phrase as well hang for a sheep as a lamb, which is relevant to the fact that if you have the same punishment for two crimes, might as well commit the more profitable one. So that initially interested me because there's an argument by Gary Becker, who is a prominent economist, a Nobel Prize-winning economist, one of whose areas of interest was law and crime in particular. And he sketches an argument which looks as though it implies that you should always impose the highest possible punishment and just vary the probability with which it's imposed. And he has an explanation of why you don't do that, which I think is wrong. I've got a different explanation. But it occurred to me that it looked as though what was called the Bloody Code, the English 18th century laws, looked like an example of that. So I got interested in it and discovered all these other interesting things about it. But it turned out that just as with the Chinese case, the system on paper and the system in the actual world were not the same. It turned out that if you were charged with a capital offense, non-clergible felony was the usual term, you had about 1 chance in 8 of actually hanging. And if you were convicted of one, you had a less than even chance. There were a bunch of different ways out. One of them was that the jury, what was referred to as pious perjury, the jury, if they didn't think you ought to hang, could find you guilty of a lesser included offense. So you have cases where somebody stole more than 40 shillings in money as well as some other things and was found guilty of stealing 39 shillings. Thus making it a non-capital case. But they also had extensive pardons, so that it was entirely possible that you would be condemned by the judge to be hanged by the neck until dead, and then sent home and told not to do it again. And part of what was going on, I think, was what I think of as price discrimination in punishment. That you say, we'd really rather not hang people. They can't pay taxes. They can't work in productive things after you hang them. So we will scare all of them. And the ones who we think are not really a problem, are not likely to repeat, we will let off with some lesser punishment or just pardon and send home. But a different way of looking at it, which I have some evidence for because there are notes of somebody who was a lawyer in this system. And it looks as though a lot of what you did in order to get pardoned was to get important people such as your employer or the squire in the district you lived in to petition on your behalf, to petition the crown in theory, although I'm sure the king didn't really read the petitions, to let you off. So imagine that you are somebody, some ordinary peasant type person in a particular area of England, and there's a local squire, a sort of very low, the equivalent of very low level noble. And he would like to have the people in his village want him to like them, to approve of them. And they would, so one of the people in the village gets caught stealing a sheep. Well, the squire of the village probably doesn't have enough political influence to get him off. But one of the things that the local nobles want, local nobles may well have a seat in parliament or own a seat in parliament, given the way that system worked at the time. One of the things they want is to win elections, which is easier if local squires support them. So one way of looking at it is the system where it's in the interest of ordinary people to have their social superiors approve of them in order that the social superiors will petition on their behalf if they're convicted of a crime. So that's why I think of it as a market for mercy. And I'm not sure that's what's going on, but I think that's a plausible interpretation of it. Islamic law. I should say what I'm describing as Islamic law, which is the traditional system in the Islamic world, doesn't exist anymore. That Saudi Arabia is the closest, but most people talk about Sharia. First, it's not clear that that's the right term for Islamic law. Arguably, Sharia is law in the mind of God, and fiqh is human jurisprudence, the attempt to apply it on earth. But aside from that distinction, what's really going on is that almost all modern Islamic countries have a modern legal system, some of whose rules are borrowed from fiqh, from the traditional system. One of the central features of the traditional system was the separation of law and state. The law was not made by the ruler. In theory at least, the law came from religious sources. The Quran, which is the text, Hadith, which are traditions of things that Muhammad and his companions did and said. Elaborate rules of interpretation, because the Quran is not always consistent with itself and Hadiths are not always consistent. Elaborate scholarship to try to determine which Hadith are real, because given that a Hadith could be used to establish a legal principle, such as that I don't owe you the money that you think I owe you, there's obviously an incentive to forge them. And there's a saying somewhere that in nothing are scholars more prone to sin than the invention of Hadith. And so there was an elaborate scholarship where a Hadith had a pedigree. The Hadith would be so-and-so was told by so-and-so, who was told by so-and-so that the prophet said the following things. And furthermore, each of those people in that chain has his own reputation. So it's really quite an elaborate scholarship trying to determine what hadiths, what the prophet really wanted. Some modern scholars think that all of the hadith are forgeries. Just some of them are early forgeries. That's something that most Muslim scholars would disagree with, but there are some non-Muslim scholars of it who have that opinion. The result of all of this is that Sunni Islam has 4 different schools of law. They're all mutually orthodox. That is, each of them regards the others as not heretics, but they have detailed differences in interpretation of the law. In each case, there is, at least nominally, at least supposedly, a first scholar who developed ways of interpreting the law, of interpreting the sources, and then a tradition coming down from him. Also, Islamic law really covers what we would think of as both law and morality, so that the categories of the, if you consider a particular act, it could be prohibited, and that's one that certainly you shouldn't do and might well be legally forbidden. It could be disapproved of, in which case there's no legal bar to it, and maybe you should do it, but really good people don't. It could be neutral. It could be the positive side of either of those, something that you ought to do or something that you must do. So in that case, and that's relevant to the system because one of the things you ask for a legal opinion about is not a legal case. You can ask for legal opinions about legal cases, but you can also ask a legal person about what should you do. The judges are appointed by the ruler. The judge is called the Qadi. But the other person in the system is the Mufti. And the Mufti is a legal expert who is not appointed by the state. He is somebody who has the reputation of being a scholar of the law. So you have a problem, and it may be a moral problem, as we would say, or it might be a legal problem. You go to a Mufti, and you say, can you give me a fatwa? A fatwa is an advisory opinion. The opinion is not on the facts of the case. The Mufti doesn't know those. The opinion is on the application of the law. So that in the American system, at least, you first have a case of first impression where the judges and the jury are trying to figure out what happened. And then if you appeal it on the grounds that the judge got something wrong in the law. An appeals case does not re-litigate what happened. You only appeal on the grounds that this interpretation of the Constitution was wrong or this interpretation of the statute was wrong. The Islamic system reversed the order. That the Mufti is doing the equivalent of the appeals court. He is writing a description of the relevant law. If it's a law case, if it's a moral issue, that settles it. You know what the facts are. If it's a legal case, you then go to the Qadi and you sue somebody or whatever the dispute is about, and you give him the fatwa. And that informs him about what an expert thought the law would be. So in that system, it is desirable that the Qadi should himself be a legal expert, but it's not essential because he's got somebody else to do that job. It was a polylegal system, a system in which in the same city there were multiple law codes, depending on who you were, basically what community you were a part. So you had the 4 mutually orthodox schools. In some areas, one school will be dominant, but in a big city, there would probably be adherents of all 4 schools. And a legal system for the Christians under Christian law. For example, there's nothing illegal about Christians or Jews drinking alcohol, which is forbidden to Muslims. And the Shia. I was describing the Sunni system. The Shia split off. You had a sort of like the Catholic Protestant split, only somewhat bitterer than that has ended up being early in the Islamic history. Basically, it was a dispute over who should have been Muhammad's successor, the leader of the community. And each of them has its own system. When you are forming a contract, a partnership, a marriage, you do it in the court of a particular school. And then disputes are settled under the rules of that school. It's rather like the way U.S. corporate law works, that most corporations are incorporated in Delaware because Delaware has specialized in trying to design law that corporations will like, and the internal rules of the corporation are determined by the state it's incorporated in. This gives the states an incentive to compete on making good law from the standpoint of corporations. And one case where you can see the issues and the reason it's an incentive is that, as you may know, Elon Musk, early in Tesla's history, made a bet. And it was a bet which everybody at the time thought was a losing bet. He basically says, I'll work for free if Tesla prospers more than anybody could expect it to. I don't remember what the criterion was, but something like 10 times or 100 times its value. I then get a whole bunch of Tesla stock. So I'm basically betting that I'm talented enough so that I'm going to work for either nothing or $10 billion. I don't remember what the sum was, but it was that order of magnitude. He succeeded in doing it. He won his bet. And then a Delaware judge said, no, this is not legal. The stockholders were not properly informed and so forth. And so the stockholders revoted it, and they again confirmed it, and Musk moved the incorporation of Tesla out of Delaware, which meant that they can no longer collect whatever benefits they had gotten from having this. So in a sense, the Islamic system as a polylegal system, there are a lot other examples. And one of the things I discuss in the book are societies where there are multiple legal systems coexisting and how the problems they rise and so forth. And there's no real problem as long as the legal disputes are within a single community, or within Maliki versus, that's one of the schools, Maliki versus Maliki. There are problems how you handle the cross cases, which I discussed some. There is a pattern that I see in a number of different societies. I first saw it in Iceland, but in fact I've since seen it in others, of private decentralized law enforcement. Saga period Iceland, northern Somalia before the creation of the country of Somalia, which was a mistake. The Romanchal, who are the Romani group, the main Romani group in England at present. The Plains Indians. And they have roughly similar systems for what I call feud law. I've sometimes described the Romanchal legal system as a primitive version of the Icelandic version of the Icelandic legal system of 1,000 years earlier. And I've argued that many and probably most modern legal systems were built on top of feud law. The European from Roman, the Anglo-American from Anglo-Saxon, and if you look at Jewish law and Islamic law, I think there's evidence, what I think of as fossil evidence in both of them, that they were created on top of feud law. So let me tell you about feud law, because it's sort of fun. The basic rule of feud law is that if you harm me, I threaten to harm you unless you compensate me. And there are 4 different problems that a feud law system has to solve in order to be a workable legal system. I should say, by the way, that feud and feudal sound similar but have nothing to do with each other. If you look at the etymology, they come out of different Proto-Indo-European roots. One problem is there has to be some reason why right makes might, some reason why the threat works if you really have harmed me and works at least much less well if you haven't. There needs to be a way that I can commit myself. Because after all, when I claim that you harmed me, You cut wood in my forest or something, and you deny it. And I say, well, I'm going to kill some of your animals if you don't compensate me. And you say, well, if you do that, I'll attack you. And maybe I'll kill you. So there needs to be a reason why I will carry out my threat. And ideally, we would like a form of commitment that survives my death. Because otherwise, if a lot is at stake, your obvious solution is to kill me and finish the matter. You need some way of protecting the rights of the weak, because this all involves individual use of violence, essentially. And you need a way of terminating feuds. You don't want to have a situation where each side thinks he's in the right, and it therefore goes back and forth, which is the way a lot of people imagine feuds happening, although I think the evidence is that doesn't happen very often. Real legal systems have shown solutions to all four. Let's start with right makes might. You need a reason why my threat is believable if you did wrong me and not if you don't, so it's not a method of extortion, which is obviously the danger in such a system. In Saga period Iceland, they have laws, they have courts, but no executive arm of government. So the prosecution and the enforcement of the verdict is all private, but if I've won my case, then everybody else in the society knows you, and you haven't paid me off, well, you're an outlaw, and therefore it's legitimate to kill you. And it is tortious to defend you. So if your friends try to defend you when I try to kill you, they'll get in legal trouble with the relatives of anybody they hurt. More generally, you need reputational enforcement. You need some mechanism so that third parties can tell whether you're an extortionist or just a law-abiding person, because extortionists are undesirable neighbors. Commitment mechanisms. We start with one that's built into us. Vengefulness is a human instinctive emotional behavior. And we observe it even before humans. I don't know how much you know about territorial behavior, but there are multiple species, mostly birds and fish, but some mammals, which are territorial. And the way that works is that an individual of the species in some way marks the territory he is claiming, and he then turns a switch in his brain, that's my metaphor, but I think it describes what's happening, such that he will fight more and more desperately against a trespasser of his own species and gender who comes onto his territory. And the central fact here is that unless the strength of the two individuals is very unequal, a fight to the death is a loss for both. That it doesn't do you any good to kill him if you only got crippled. Therefore, once it is clear to the trespasser that you will fight him desperately, he backs off, usually. So I like to claim on that basis that property predates our human species. It's not only not an invention of government, it's not an invention of mankind. You can also see elements of that in yourself by introspection. My standard example is that if I bump my head against something, I feel a surge of rage. There's nobody to be angry at, it's just my own fault. But that's your reaction to being hurt. And the fact that you have that reaction means that you have an incentive to carry through on your attempt to get compensated. Reputation. If I demand that you compensate me and then back down, I'm marking myself as a target. Other people will know that it's safe to wrong me, to rob me, or whatever you've done. And I want the reputation of being someone not to wrong. That's essentially the same point I was making earlier in the English case as deterrence as a private good. Status. Human beings care quite a lot about status. There's an economist whose, I think, most important contribution was showing how the concern by humans with status could be incorporated in ordinary economic analysis. Nobody wants to be seen as a wimp. How do you do it past death? in a system like the Icelandic, my kin the microphone just came off. You kill me, now in Iceland, my heirs have a claim for a couple of 100 ounces of silver, weregeld, the punishment for the fine, the damage payment for killing somebody. They have an incentive to enforce it, both because they'd like the money and because they want to establish that killing their kin is expensive. So that next problem is, how do you protect the weak? Iceland is my favorite solution to that one, though I'm sure there are, well, I know the versions in Somalia, and I don't know the others. In Iceland, tort claims are marketable. So imagine that I am a poor elderly man and somebody kills my only son. If I try to sue, I'm never going to get to court. I'm going to get beaten up by somebody working for the guy who I'm trying to sue. If I did somehow win the case and the guilty party was outlawed, I can't kill him. However, my neighbor has 4 strong sons who went a Viking in their youth, and relatives and friends and allies. So I transfer my claim for 200 ounces of silver weregeld for killing my son to him. He sues and collects. Maybe I get some of it, maybe not, depending basically on how hard it is to collect it and how generous my neighbor is. But the critical thing is that the killer pays, and therefore there is an incentive not to wrong me, even though I can't enforce it myself. So I like to claim, I've got various discussions of how this would work in a modern system and the functions it would serve. In Somalia, a dia paying group. I would say I probably have a later slide which has the line I like to use, which is that in this respect, modern day America is a mere 1,000 years behind the cutting edge of legal technology compared to Iceland. In Somalia, you've got this weird and neat and intricate system in which everybody is a member of a set of nested coalitions. So the lowest level coalition usually consists of the descendants of your paternal grandfather. And they are all allies. But then go one step up in the tree, and you have a larger group, which those groups are part of, and go on. And it doesn't have to be done by kinship. It's most commonly done by kinship. But they have the term a pile of shields, which is a group not defined by kinship, which is just exists in order to get enough people to defend themselves. And their term for the NATO alliance, for the Western alliance, it was a pile of shields. Because after all, we aren't kin. And yet we are committed to. So the way a dia paying group works is that if a member of the group is wronged, the group has the obligation to help him get his compensation. If a member of the group is found guilty and owes compensation, the other members of the group pay part of the compensation. I should say a very similar system existed in early Islamic law. The last year I taught this course, my class consisted almost entirely of Saudi LLM students who would come to the law school. So I had primary sources in my classroom because Saudi is the closest thing to the traditional Islamic law. And I had been told in the secondary sources that the Arab equivalent of this system had disappeared a long time ago. And they told me it wasn't true. All of their names were a reference, their last name, as it were, was a reference to which group they were in. These were the descendants of tribes originally. But it was I don't think it was a nested coalition, but it was a defined group who had the obligation of paying part of your damages if you were found guilty and of helping you if you were wronged. they also only marry within the group, which is a problem. I don't think that was true of the Somalis. But in any case, that was sort of neat. How do you terminate feud? And the basic problem is, you think I wronged you, not me. I think I didn't. You demand compensation, I refuse. You harm me now. I think I was wrong, so I demand compensation, and either of us who backs down looks like a wimp. And there are basically at least two solutions to this problem. One of them is a court, that if I've lost the court case, then I'm not a wimp for going, I'm just a responsible Icelander for going along with what the court said. The other solution is an arbitrator. You find somebody who is powerful and respected, who agrees to arbitrate your dispute. And now we promise to accept his ruling. What enforces that promise? If he rules against me and I accept, I don't look like a wimp. And if I don't accept, he joins the coalition against me. And he was chosen partly because he's a powerful person. What does all of this tell us? It doesn't tell us that a feud system is better than a modern system. We don't have a basis for that comparison. But it tells us that it is possible for private institutions to replace government in what we think of as its most central function, law enforcement. And that, to my mind, is interesting. In my first book, The Machinery of Freedom, I sketched what I imagined a fully private modern legal system might look like. And one result of teaching the course and learning all of this stuff is that I now know that I was reinventing the wheel. That I was describing a modern developed society version of what has existed in a much more primitive form and has functioned for, the Icelandic system lasted about a third of a millennium, a bit over 300 years. Of what has existed in primitive form, that's form, not foreign, in the past. In addition to the chapters, of which I've given you only a small sample, on legal systems, I also have what I call thread chapters, which are taking a particular issue that shows up in multiple legal systems and discussing it. One of them is when God is the legislator. How do you manage, in particular, if God gets it wrong? What do you do in a legal system if it turns out that one of the rules you believe is divinely inspired doesn't work? Embedded legal systems like the Amish and the Romani, systems where a society, where a subgroup in a population enforces rules against their own members, even though they are theoretically under the rule of society. Incentive to prosecute. The problem of who guards the guardians. How do you prevent whoever is in charge of enforcing things from themselves violating the rules, which is a big problem. The problem of error. How do you deal with the fact that verdicts are sometimes wrong? And the issue of how do you make law. Since this is a talk and not a book, I'm only going to discuss one of those briefly, and that's the incentive to prosecute. Because in order for a law to get enforced, somebody has to prosecute. So there's got to be some incentive, some gain to prosecuting. And you want to get the right incentive. You don't want a situation where if you've, done some very minor harm, people spend huge resources trying to prosecute you. And in particular, you don't want situations where there's an incentive to prosecute innocent people, which can happen. One mechanism is a state employee with the job of prosecuting, and that was the Chinese system and our criminal law. One of them is damage payments that the prosecutor collects. That was the case in the Icelandic. It's the case in Gypsy blood feud, which I haven't discussed, but the Gypsy is one of the societies that uses feud, some Gypsy groups. And in our tort law, that's the incentive to sue somebody. One incentive to sue somebody is to punish him so people won't do bad things to you, but another incentive is to collect damages. a bounty. In the Athenian public case, the successful prosecutor gets a share of the fine. In England, there were some particular crimes where the officials were worried that there wasn't enough incentive to prosecute, and therefore set up large rewards for successful prosecution. And there's the incentive of extortion from the person who you can prove is guilty, and you won't do it if he pays you off. And that is an incentive to prosecute, although not to finish the prosecuting. But it also results in a punishment, although the punishment is not a visible fine. And private deterrence, I've already discussed. The problem of too much incentive. Harassment or extortion in Athens, and I've described the solution, which was 1,000 drachma fine if fewer than 20% of the jurors voted for conviction. Fine on the prosecutor. And the fact that a losing tort plaintiff owes the defendant a sixth of the amount that he sued for. In mid-18th century England, the problem with rewards, which you have to worry about with any of these systems, I don't have it what it is. The basic problem was that when the reward was large, there was an incentive for people to either frame people or create crimes in order that you could then betray the people you got to do it. So you have an Irishman fresh off the boat who doesn't know much about England, and some friendly fellow says, look, we should rob a stagecoach. And they then arrange it such that the confederates of the person who's setting it up detect the stagecoach robbery, detect only the Irishman, not the other guy involved, and they then collect a very large reward from the English government. And that was enough of a problem so that they more or less abolished the rewards and replaced them with a system where you could get part of your costs of prosecution reimbursed, but didn't have rewards. Modern American concerns about class actions, about punitive damages, about various ways in which people sue, people accuse other people of crimes, not because they're guilty, but because they can get money out of it, or of torts usually. So ideas we could use. That's a chapter in the book. One of them is Icelandic marketable torts. One of them is, well, for the marketable torts, one of the things that could give you is a better solution to the class action problem. The class action problem is somebody does something that imposes a small cost on each of a very large number of people. So it's $10 damages to each of 1 million people. Well, 10 million is worth suing over. $10 is not. And the present system is that a lawyer gets a few of the people who are victims to appoint him basically to sue for them and all others so situated. He gets a judge to approve of this process and then sues for everybody. And the problem is that since the people he's suing from are not really his clients, they haven't chosen him, he has an incentive to settle for terms that give as much money as possible to the lawyer and cost as little as possible to the defendant, which is why the defendant is willing to agree to them. So I think of sort of the typical result is $1 million legal fee to the lawyer, $10 million to the defendant in the form of offering discounts on another product of the defendant, not in the form of actually giving them $10 million. In principle, the judge tries to prevent this. But my better system, with transferable tort claims, is you have a company that deals with large numbers of people, say an insurance company. And the insurance company makes the following offer. If you will sign over to us all of your claims for damages that are for less than $100, we will give you a discount on your insurance. Now the lawyer who realizes that this company's cans of spoiled beans have imposed a $10 cost on each of a million people, goes to the insurance company and other firms that have engaged in this, buys all of their claims for spoiled beans, and then he sues on his own behalf. He now owns all of those claims, and the victims have gotten reimbursed in the price at which they sold their claims rather than in the case itself. So that's sort of one of the ideas that strikes me as a way in which it could be useful. But it's also true in much simpler cases that somebody damages your car and you don't know, you may not have the money for a lawyer, you don't know what lawyers you should choose. If claims are marketable, you just auction off your claim for damages to the highest bidder. The Athenian rule for damages, I've already discussed how that works. In terms of feud as a way of understanding things, I argue that a good deal of what goes on in high-tech patent litigation can be viewed as feuds, that part of what limits Samsung's ability to sue Apple for claimed copyright infringement or patent infringement is that Apple can also sue Samsung for the same thing, and therefore each of them has an incentive not to harm the other, even in ways that would profit them. And the problem in that system is what are called non-practicing entities. These are firms which own lots of patents but don't use any of them. And the reason to own patents is so you can sue people. And the point is that they can't be countersued because they're not doing anything with anything that could infringe anybody's patent. So they're like somebody in the Icelandic system who has perfect armor, can't be hurt. And that's a respect in which the legal system doesn't work very well for that case. Finally, what I think of as the problem of the king's friends, the fact that if the crown controls prosecution, the king's friends can get away with murder. And that's partly based on a real case in 18th century England, where arguably at least the murderers were the brothers of a woman who was the mistress of several highly ranked political figures and didn't get prosecuted. And in England, in principle at the time, though it no longer worked very well, there was a way in which a private party could initiate a criminal case himself, and some people tried. They didn't succeed in that case. But in general, if you have the option of private prosecution, that reduces the ability of the government to let off people who commit crimes that it approves of. And I can think of a number of examples in my lifetime in America. The first one that struck me, actually, back when I was a graduate student at the University of Chicago, a group of Chicago policemen came to an apartment full of sleeping Black Panthers, opened fire and killed 2 people. They claimed that the Panthers shot first. And I mentioned to a left-wing friend of mine that I didn't trust either the city government or the Panthers. And she told me that the Panthers were offering a tour of the apartment. When a bullet goes through a wall, you can see which way the splinters point. There were no outgoing shots. And the police involved were never charged with murder, which was pretty obviously what they had committed. However, the survivors sued and got a multi-million-dollar settlement from the city, state, and county, maybe federal government as well. So that I take as evidence of the advantage of a legal system where private parties can initiate cases, in this case, cases against government action. So, for much more on this stuff, legal systems very different from ours. You can get it from Amazon.com in print or Kindle or even audiobook, I think. And You can also read a very late draft of this for free from my webpage. That's what I've just clicked on. This will show you what the lists are: Imperial China, Chinese, Amish, Jewish law, Islamic law, when God is the legislator, pirate law, prisoners law, embedded in polylegal systems, and so forth and so on. This is a list of chapters. For my version, you can read The Machinery of Freedom, which is my first book, which can also be downloaded as a free PDF from my website, or bought in the usual fashion. And I have a Substack, which I post on every 3 days, and a web page. The web page has most of my writing on it available to be read for free. One of the things it has is my Substack posts sorted by topic. That's the list of topics, and there are a lot of them. A number of my books came out of courses I taught, such as this one. And I'm not teaching courses anymore because I'm retired. So instead, I am using my Substack as a way of doing bits and pieces that can eventually be put together for a book. And I have, the first book is coming out pretty shortly. I've got it written and I need to get more comments on it. And that's on the consequences of climate change, which is something that I think I'm giving my last talk on this trip on. It's a good way of getting me to write.
But you don't write on physics.
What?
You don't write articles on physics.
Article on physics.
Studied physics.
Yes, I switch. I object to being called a physicist because I stopped doing physics 50-some years ago. I like to say that the only benefit of having a doctorate in physics for an economist is that I can do non-mathematical economics without people thinking I'm afraid of mathematics. So anyway, I think this covers what I wanted to say, and you can all get lots more stuff from my webpage.
Any comments you might have?
Comments, questions?
I mean, I have a comment. We have a libertarian split about the IP laws. In the Amish, civilization, we can see that they thrived because they shared knowledge. So, should we abolish IP laws? Or
I believe that I may be the only libertarian in the world who does not know the answer to that question. They disagree on what the answer is. That Ayn Rand thinks that intellectual property is the most, or thought when she was alive, the most defensible form of property, and many other libertarians think it's the least desirable. And I think there are, in fact, arguments both ways. If you want an argument against, which includes patent as well as copyright, there is a book you can find online called Against Intellectual Monopoly by a couple of economists. And they argue that the progress of the steam engine, which is a sort of standard example, was actually held back by the fact that the original inventor had a patent monopoly. Right. That he did not incorporate the improvements other people made, and they weren't able to make them because of his patent. So, but I don't know. I'd have to, it's an interesting question, and I think on theoretical grounds, there are arguments both for and against, so I don't want to make it plain.
Also, owners in the ancient Athens, were held accountable about their slaves, the damage that the slaves are made. Do the same should be guaranteed with the AI developers with their agents?
Huh.
I mean, even now, AI agents escalate things more than they should.
But the question is this a result of voluntary interaction with people with the agent? Because my view as a libertarian is that if I give you good advice and you choose to believe it, unless it's deliberate fraud, unless I tell you things that I know are not true, I'm not liable for the fact that you believed me when you shouldn't have. And so that would be true for an AI as well. So you'd have, the interesting case in a sense would be the case where the AI actually committed crimes, where the AI.
Yeah, exactly. Cyber attacks.
What?
Cyber attacks.
But then the question, then do you also think that parents should be liable for the crimes of their children? Because we create them too.
Yeah, that's a good question as well.
That
Yeah.